Looks like everyone is ready. We will begin with Mr. Tunink.
Thank you, Your Honor. May it please the court. I'm Ryan Tunink here today on behalf of the Assistant County Attorney for Story County, Theron Christensen. We're asking the court to sustain our writ of certiorari and find that the district court abused its discretion in imposing a sanction against Mr. Christensen in this case. As this court is well aware, there were three separate bases for the district court's imposition of sanctions. The first is a 4-page motion in limine that was filed on August 28th, approximately 3 weeks before the trial was set for this matter. The second was Mr. Christensen's decision to dismiss the case on September 13th or 14th, depending on when it was exactly filed. And the third is a consideration of 2 prior cases Mr. Christensen prosecuted, one of which occurred over 2 years prior to the events in question. We believe the district court erred in its application of facts and law as to all 3 of those grounds. I'd like to start first with the motion in limine because I think it's really indicative of how this court misapplied both facts and the law here. As again, the court is aware, there were 3 separate arguments in the motion in limine. The first was to exclude the second of 2 test results that were obtained by a data master in this case. There was, of course, the .091 result and the .08 result, both of which were undisputably valid tests according to the DCI agent who was deposed in this matter, and he is the only testimony that was available to the district court opining on whether or not those tests were valid.
Just based on my own experience, I assume defense was the one that asked to depose a DCI person? It's the state's witness, and it's the state that wants to eliminate out their own witness's testimony.
Your Honor, and I think that's an important point here because the motion in limine was actually pretty narrowly tailored as to what portion of Dr. Lappy's testimony it sought to exclude. The only evidence that was to be excluded was his personal opinion that is not representative of Iowa law, that if an officer obtains a data master result of 0.1 or below, that they are obligated to perform a second test.
Experts, though, they especially was that garnered during during the defense attorney's questioning? Was that testimony elicited? Yes. So they play games like that all the time. They always try to water down what the expert has to say by giving them crazy hypotheticals. Why is that so wrong? Why can't we leave it up to a jury to know, okay, that's crazy?
Well, unfortunately, I don't think a jury is well equipped to decide that kind of issue. First off, as a matter of law.
Why can't a jury consider something an opinion? Couldn't the state just argue, that's his opinion?
You still have to meet basic relevancy standards under a rule of evidence. Whether it's expert or lay testimony, it has to be relevant and has to assist the jury. A personal opinion of what law ought to be does nothing to assist the jury in deciding the question before it, which was, did Mr. Clemens operate above the legal limit of 0.08 on June 29th and June 30th is when the data master results were actually taken. Whether or not there should or should not have been a second test, or whether the law should require that second test, doesn't help the jury make that determination. I would also like to talk briefly about the motion limine regarding Mr. Clemens' demeanor during the traffic stop. As this court is aware, under 321J.2 sub 1, there are 3 separate theories of prosecution available to the state for an OWI offense. There's under the influence, which is focused on demeanor. There's the per se theory, which is whether or not the offender had a blood alcohol content above 0.08. And then there's a third one for other controlled substances that's not at issue in this case. Here, the only theory of prosecution was that per se theory.
Assumption that the science of that is completely unfettered, that there's no problem with your machine, there's no problem with operation. And let's say that the defense pokes holes in that and they find maybe, I'm not so sure about that machine. Doesn't it all of a sudden become really relevant? What was he like? Was he vomiting? Was he putting the cone on his head to do STs? You know, how can that not be something that a defense can talk about?
I would point the uncontroverted testimony from Dr. Lappy was that it was a valid test. And as Mr. Christensen put, particularly in his response to the request for sanction.
Following up on the Chief's point, I mean, the issue on the per se theory is whether or not he was above 0.08. doesn't it make it more likely that he was above .08 if his demeanor is one of someone who's intoxicated, and less likely if his demeanor is of someone who's not intoxicated? And so why isn't it relevant? I mean, it strikes me, you're taking the hardest path if you're trying to convince us that these arguments in the motion in limine were correct. It might be that they were incorrect, that they were pretty weak arguments, but that it's not sanctionable. That I'm more interested in that path.
Your Honor. And I'm glad you bring that up, because ultimately the inquiry for this court, Mr. Justice Mansfield is exactly correct, is not whether or not Mr. Christensen was correct in his positions. It's whether or not they were colorable under existing law or under a good faith basis to interpret matters of first impression or extend or reverse existing law. Here, Mr. Christensen, particularly in his response to sanctions, identifies a litany of cases from other jurisdictions saying that a demeanor has no relevance to a per se theory of prosecution. Now, again, this court may understandably.
Then, if a prosecutor wants to argue per se, defense isn't, what can they talk about?
If they had obtained some form of evidence to suggest that the data master result was invalid, such as testimony from the DCI agent who calibrates it, or
a test that Christensen also tried to exclude. Can you address what colorable claim he had to excluding that test?
in the motion itself, he identifies 321J.2 sub 14. And I think it's certainly a fair point that the appellee and the district court raised, which is that the plain text of that statute probably doesn't get Mr. Christensen where he needs to go. But that was not the only portion of the argument that he included. He also argued that we have two conflicting presumptions here under 321J.2 sub 12 that permits the jury to presume that Mr. Clemens simultaneously had a 0.08 blood alcohol content and a 0.091. That necessarily, I think, Mr. Christensen raised a valid point, would confuse the jury, whereas one is within the margin of error and does not have an evidentiary value, and one does in fact have evidentiary value, being outside the margin of error. An attempt to clarify that to the jury, I think, was a colorable argument.
The jury, we're only going to present them with the one that's more favorable to the state and prevent the defendant from also letting them know that there was another test that was done.
There is a legislative determination within 321J.2 sub 14 that a result within the margin of error is not reliable enough to prosecute.
Why is that? It's because it's not because you don't meet the threshold of 0.08. So why should the defendant not have the benefit of saying, look, I blew 0.08 and under the statutory scheme that's not within the margin of error, so I actually was less than 0.08. What authority would support Christensen's view that that was a valid tack to take?
I still think his argument as to juror confusion, he elaborates on this in his subsequent response to sanctions, that it additionally puts the state in a precarious position where the state can't bring up this 0.08 result, which would suggest to the jury that it's withholding information, but then the defense can bring it up as they see fit. It disadvantages the state in a manner that I think the motion eliminate would have produced a reasonable result.
The sanction here, Amicus refers to the civil rules as the basis for providing a monetary sanction. What's your position on that?
I think if I'm correct, that's the Attorney General's amicus brief. And I think they raise really important issues for consideration. Unfortunately, those issues were not raised below and are likely not preserved for this court. By my reading of the Attorney General's briefing, it's premised on an authority issue, and having not briefed that below, it would be waived.
We affirm a sanction under a rule that doesn't apply.
I think that's fair, Your Honor. And if the court wishes to address that, certainly, given the unique context of a criminal proceeding, as the Attorney General briefs extensively, there's absolutely no reference to sanctions under rules of criminal procedure. And through our common law tradition of absolute immunity, I do think imposing sanctions on a prosecutor is improper.
Code 619.19?
Repeat that?
Code 619.19, does that not apply?
That likely would apply, Your Honor. As a separate statutory provision, there's nothing within the text of that appears to limit it to a civil proceeding.
So I thought it was limited by its terms to pleadings.
Directly in front of me, certainly I would defer to the court's reading of that statute.
Subtitle 3 of the code, which is entitled Civil Procedure. So it raises this question of whether or not it ought to extend to the criminal proceedings or not.
I think that's fair, Your Honor. And
Is also in subtitle 3. Does that apply in criminal proceedings?
I do think there is the canon of interpretation that, the subsection that something's under does not necessarily control its application.
Pleadings, which you don't really file pleadings in criminal cases. That's a civil term, right?
I would also like to move briefly,
How can it be sanctionable to dismiss a criminal case?
up, Your Honor. I was just about to move to that issue. Certainly, this is an odd case where the defendant is claiming some form of prejudice by the fact that a case was dismissed against him. That's not, the court faulted it as an improper purpose, but I think the case law about sanctions focuses for the purpose element on how it affects the opposing party. We don't want people filing things that raise the cost of litigation, that are meant to harass and embarrass. It's not supposed to be a purpose element for, did they have this ulterior thing in the back of their head that in no way impacts the opposing party. I also think it's important to note here, the whole theory that the district court relied on was that Officer Schreffler made a mistake. There's nothing in the record that actually establishes that Officer Schreffler failed to properly calibrate his radar unit. The only evidence that came from that was briefing done by the defendant where he states his own personal opinion is that that was a failure to calibrate. And that's not properly in a record as an evidentiary point. I also think in terms of that, the district court simply relied on an illogical assumption as well, in that a dismissal would do anything to cover up Officer Schreffler's conduct. The deposition was done in front of the defendant. The testimony was actually elicited in part by Mr. Christensen himself. There was no protective order. None of the motion and limine points sought to restrict any testimony as to Officer Schreffler's conduct. There was simply nothing being hidden here. Further, an adjudication wouldn't change the defendant's position. He did not have his license administratively taken by the DOT, which distinguishes the Traeger case that district court relied on. So I think that the court's assumptions here are fundamentally flawed and demonstrate how it abuses discretion.
You talk about one little thing all by itself. I tend to agree with you that, that's not, there's something colorable there. That's not such a big deal. But you look at the whole picture of what Christensen did, you smell a rat. I mean, every step of the way, defense kind of catches up with him, and then he does something else. And then his own witness says, no, I'm not going to testify to that. Okay, fine. I'll amend the minutes again. Now I'm going to admit that you won't say that. And then there's sanctions hearing coming up, and all of a sudden, okay, fine, I'll dismiss. You put it all up together, and can you see why you smell a rat?
I respectfully disagree with that interpretation, Your Honor. And I think particularly as a young attorney, Mr. Christensen is a young attorney when he was doing this. But the way I read it,
Attorneys.
read it more as an intimidation factor. There was an experienced attorney who filed a motion for sanctions against a county prosecutor who did not have a ton of experience under his belt, had limited financial means, and now he's being taken to task for what was, at the end of the day, a 4-page motion that, for the reasons in our briefing, we believe presented colorable arguments. He also did have
Argument you could make if the motion in limine, and I've had that happen as a baby lawyer. I remember a seasoned lawyer filed a motion for sanctions in my very first trial. Didn't think much of it, and then I found out that's not normal. But anyway, if he'd have stopped dead in his tracks and done an about face, I think the young and green and inexperienced would carry some weight. But he kept taking it. He kept pushing it, didn't he?
And my time's running short, so may I briefly conclude?
Did I ask the question?
I don't believe that the docket in this case reflects that he kept doubling down in the manner that I think the question posed. First off, the entirety of these events span from August 28th to September 14th. It's a little bit over 2 weeks. There's not a ton of time for analysis for any given case in that short of a period. Also, for instance, he wasn't simply kind of pretending or changing what he believed his expert was going to testify to. On August 28th, when Dr. Lappy was deposed, he stated he can't do a retrograde extrapolation unless he had more information provided. The September 7th additional minutes of testimony stated that Mr. Christensen then provided that information under the belief that the retrograde extrapolation could be possible. It wasn't until 11 p.m. on September 11th that Dr. Lappy notes that it was a misunderstanding. He thought that Mr. Christensen was asking for a different test. And then it was the very next morning when Mr. Christensen corrects that mistake. So I don't think it's he's getting caught and makes these efforts to hide the ball. He's responding to the changing circumstances that could only have developed over the course of discovery. Thank you.
Mr. Lindholm.
Good morning. Counsel, may it please court. My name is Matt Lindholm, and I'm here on behalf of Mr. Christensen. As I stated at the district court, this isn't something I'm proud of. This isn't something that I enjoy doing. In fact, it's something I've never done before.
On your website?
And there's a reason for that, Judge. And the reason is that these rules, these two rules that are here before you, or a rule and a statute, are gatekeepers for our profession. And those rules are to ensure the integrity of our profession, to keep frivolous motions from being filed, and to ensure that people defending those motions aren't needlessly tasked with expense and time in doing so.
To this question of do they even apply in criminal cases? 619 seems to me a chapter that's just about civil matters, chapter 619. Clearly, Rule 1.413 is a rule of civil procedure, not criminal. So what's your authority, and maybe the argument's not before us, but what's your authority that those provisions apply in criminal cases?
One, I would submit that the issue isn't properly before you, but the authority for the rule of civil procedure applying to criminal proceedings is Rule 1.101 of the Civil Rules of Procedure, and that was pointed out in the State Public Defender's Amicus. That rule succinctly states that where the rules are silent to a particular course of action, the civil rules apply. Because there is no rule for sanctions in the criminal rules, then by default under Rule 1.101, 1.413 would apply to these proceedings.
What if it's not a gap filler? What if the intent in the criminal rules is that we don't have monetary sanctions? I think we said in the Salas case that the civil rules don't apply in criminal cases.
The DeSalis case did, in fact, say that, but it did so without reference to Rule 1.101. In fact, what's notable is that all of the cases that have said the criminal rules of civil procedure, the civil rules of procedure do not apply to criminal proceedings have never once referenced Rule 1.101, at least that I could find. And I think that that rule is instructive and must be followed by this court, and is exactly that, is as a filler for where the criminal rules are silent, then the civil rules would apply. And to Justice Oxley's point, as it relates to the statute, I mean, there are situations where things are included under, I guess what I'll call civil proceedings that do apply to the criminal proceedings, much like the spousal immunity. And the third point there to answer that question is, what are we left with? If these rules don't apply, what are we left with? I cannot sue a prosecutor. They're immune.
When they talked about a seasoned attorney beating up on a green attorney, and I had that experience. Were any, and you know the record better than I do, what efforts did you make to try and get this green whippersnapper to knock it off? Or did you go straight to motion for sanctions?
Judge, I initially sent an email to this young whippersnapper saying, you might want to talk to your experts about these two tests and the validity of them and your ability to, yeah, it was through via emails. He declined to do so, which forced me to do the depositions, which set this whole chain of events in motion. After that, Your Honor, arguably I didn't do anything further to say, you need to withdraw this. And this isn't part of the record, but my experience has historically been with county attorney, and this in particular county attorney, is that those efforts would have been futile, much like the suggestion to talk to the expert before having to do depositions. So that was why I proceeded. And, you know, what we're here to decide is whether or not the court abused its discretion in awarding, or first finding sanctionable conduct and then awarding monetary sanction. And I think it is real easy to conclude that the district court did not abuse its discretion. And the easiest way to do...
You a question. To the extent 1.413 and 619.19 apply, do they distinguish between prosecutors and criminal defense lawyers?
The plain language of them in and of itself, I don't think make any distinction at all. I think it applies to any and all lawyers, and the purpose of the rules would suggest that it would apply to all lawyers.
Whether or not we would want to apply these rules in the context of criminal cases, in particular criminal defense lawyers, you know that frequently arguments are pressed to the limit. There are frequent requests to overrule cases that have been repeatedly rejected. Do we really want to be in the business of policing, in particular criminal defense lawyers, on these kinds of issues as they're advocating for their clients in the criminal context?
The answer is yes. I mean, if we're going to uphold the integrity of the rules, I think so, or the purpose underlying the rules and the integrity of the profession, I think the answer is yes. Now, the protection there is that the attorney making those arguments has to make a colorable argument as to why they're attempting to go the route they're going, whether it's to overturn an existing law, whether it's to distinguish prior cases, whether it's to advance some new argument. But that wasn't done here. And that is, I think, the message that this court can send to the bar generally, is that if you're going to make an argument that isn't necessarily supported by current law, then you've got to ferret out and explain what it is you're doing and why you're doing it, and support it with authority, whether that's from another jurisdiction, whether it's a law review article, or whatever the case may be.
Integrity of the bar, and I agree that's important. There is always the option of making a bar complaint, and all lawyers are subject to that, whether they practice criminal or civil. The question here is, do we have a 1.413 type mechanism that also applies in criminal cases?
Sure. And I think the court would be ignorant of Rule 1.101 of the Rules of Civil Procedure to say it doesn't apply. I also think that the purpose of Rule 1.413 and 619.19 would be thwarted if we carve out an exception for applicability of those rules to criminal proceedings. And I mean, I'm not aware of any case that has suggested that is the norm, and that hasn't been.
That has applied this type of sanction in a criminal case to either a prosecutor or a defense other than this case?
I am not, Your Honor. I'm not aware. But I think the plain reading of them gets you there.
Nationally, if I'm understanding the briefing, there's only one other state that has granted sanctions against a prosecutor. Is that accurate, as far as you know?
I don't know if that's actually accurate, Judge. I haven't gone through each individual jurisdiction to confirm that or not. But I might suggest that this is unique, right? It is a situation that probably doesn't happen very often. And it is also probably a situation where if, in fact, there are sanctions, they don't further get appealed. That very well could be the reason there isn't a lot of authority suggesting one way or the other whether or not those rules apply.
why this situation is unique, because we do read a lot about accusations of prosecutor misconduct of all different kinds.
Are stemming from cases in trial where there's, misconduct at a trial, where there's improper argument, not necessarily because of a pleading or a motion or a filing leading up to the trial. And they're generally in the context of getting a new trial for prosecutorial misconduct or the like. So I think it's unique because of that. I also think it's unique because a lot of times when a defendant's case is dismissed, they're satisfied with that. They just move on. They don't continue to pursue the issue. And in light of what happened here, as Justice Christensen pointed out, the whole proceeding of this was a continuation of the state's efforts to take away any viable defense evidence from Mr. Clemens. And I think that's a real problem and a real concern that this court has an obligation to say, we can't do that. You can't do that. You shouldn't do that.
Can I ask you a question about waiver? This 1.413 issue was first raised in an amicus brief. We've said in at least one other case I can think of, the ABI case, that when it's a purely legal issue, we will accept arguments from amicus raised for the first time. What's your response to that?
Again, I would point you back to Rule 1.101, first and foremost, and that rule has applicability to incorporate Rule 1.413 into the criminal proceedings.
On 1.101, as I read it, it says, the rules in this chapter shall govern the practice and procedure in all courts of the state, except where they expressly provide otherwise, or statutes not affected hereby provide different procedures in particular courts or cases. We have a separate criminal rules that arguably expressly provide for a different process in criminal cases. And we have to separately go to the legislature to have those rules approved, and we've never gone to the legislature with any sort of sanction for prosecutors in those rules. So what are we supposed to do with this?
What different process are you suggesting in the Iowa Rules of Criminal Procedure would apply to this proceeding, or to what happened here?
In this case, there just isn't any monetary sanction in our criminal rules that we've ever placed in them. And we just went through them again a couple of years ago. We never provided for any sort of monetary sanction, whereas the civil rules have them and have had them for quite a while.
And I think the reason for that is because Rule 1.101 makes that rule applicable to the criminal proceedings. Again,
Temporary injunction in a criminal case to stop the state from prosecuting your client? I mean, there's a temporary injunction rule in the civil rules. Could you do that?
Judge, down in Marion County on a threat to charge a client of mine with sex abuse. I did do that.
Within the criminal case, a separate civil case you filed, right?
I don't recall, honestly, if they had filed a criminal case number and initial complaint, or if they were just threatening to. I don't remember the particulars of that. But I do think that there would be a way to do that, yes.
Recognized the possibility of monetary sanctions for criminal defense lawyers. Would we have an even harder time convincing lawyers to do court-appointed work?
I don't think so. I think as long as you make it crystal clear that if you're going to be submitting a filing on behalf of a criminal defendant, and it's not, if it's contrary to existing law or not supported by existing law, you just have to spell out the reasons for why you're making that argument and that advancement. And then it falls within the protections of both those, the rule and the statute.
Possibly have a chilling effect on aggressive advocacy by criminal defense counsel. If they're worried they push it too far, they might get fined a couple grand.
You do have to recognize that there is a difference between the obligations of a prosecutor and the obligations of a criminal defense attorney. So I think that is one facet of this that would have to be taken into consideration when you look at sanctioning a criminal defense attorney compared to a prosecutor.
Did the district court abuse its discretion by considering several earlier cases, one that was maybe a couple years older? I mean, our Rule 1.413 cases, generally you have a pretty brief time window to seek sanctions, 30 days from dismissal. Were these too far in the past?
To that, and were they before the same judge?
Your Honor, I don't know that the merits of either one of those prior two cases ever got addressed, and I don't know if they were before the same judge, so I can't answer that. What I can tell you is I think the judge relied on those for a relatively limited purpose, if at all, and that was simply to go to Mr. Christensen's state of mind. And as Justice Christensen pointed out, when you look at the big picture here, that's a telling component of what happened in this particular case. In both of those prior cases, County Attorney Christensen was also trying to thwart a defendant from presenting favorable evidence. And as the district court pointed out, that goes to his state of mind and goes to the purpose for which those filings were made. And I see that my time is up. Thank you.
Tunink. Walking up there, I shared with you that I had this similar situation, but a big difference between my situation and the one before us is I never had to take it any further. The judge immediately saw it as bullying by the seasoned attorney and immediately dismissed it. This one, you had a judge. It's not just the attorney who made these arguments and complained. You had a judge that also looked at it objectively and made this determination. So taking that for what my question is, what say you?
I think it's a fair point. However, there's a few issues there. The first is that this judge was not the one who presided over the majority of the proceedings. He was not there as the facts and legal arguments were being developed and raised. He only had this after-the-fact examination that he could perform, which under the case law for 1.413, of course, we don't judge what an attorney made based off information obtained in hindsight. So, for instance, the fact that Dr. Lappy ended up indicating he could not perform the retrograde extrapolation does nothing to suggest that Mr. Christensen had a bad faith or lack of inquiry for believing that he could when he made that September 7th minute of testimony. Additionally, the court's reasoning is fundamentally flawed here. Throughout his opinion, the court equates withholding evidence with using legitimate evidentiary rules to prevent the admission of inadmissible evidence. There is simply no constitutional violation using prescribed means and approved evidentiary rules to prevent evidence that certainly wiser minds than me have decided present logical and evidentiary issues for a jury. There's certainly Brady and other cases simply do not extend to the scope that this judge believed. I also want to turn.
We're about to again. Whether it was improper for the district court to rely on those earlier cases.
And we included in our briefing, there are several issues with this. First, just as Justice Waterman noted, there's a timeliness issue here. It's under any reasonable set of circumstances, you shouldn't have to wait 2 years to discover that a motion in limine was not supported by the law at the time it was filed. I think there's also just the simple matter of this will put attorneys at endless risk of sanctions. If any party with any judge can go back and review your work years afterwards, not only does that subject that attorney to endless liability, you're also then providing an award of sanctions to a party that had nothing to do with it and wasn't injured in any way. And that in itself perhaps opens up duplicative sanctions awards if the original party comes back and says, look at this order, we want some money too. I also, yes.
Obligation to do justice in the criminal field play any part in the sanction discussion?
To the extent that the court determines that the civil rules apply here, yes. Prosecutors do have unique ethical obligations. I do think that the defense overstates those obligations to the extent that they essentially appear to be arguing that if there's exculpatory information, the prosecution has to let that in. And it's the exact same issue that I was just discussing with the district court's reasoning.
They just say the arguments for excluding were frivolous. I do tend to agree with you that if this is sanctionable, imagine when we get to a Brady violation, because here, at least, the arguments were up front and center. The judge had the ability to evaluate those arguments and decide whether they had merit or lacked merit. And I do have a concern that this opens a huge can of worms in situations where it was not a situation that could be self-corrected easily.
That way, this case really reminds me of the Dupaco case that this court recently decided this term. We included in our notice of additional authorities. And in that case, the opinion expressly notes that the sanctionable filing was made to request an evidentiary hearing where all these issues could have been sussed out anyways. And that's exactly what's happening here. This is a 4-page motion in limine that was set for hearing. It is an isolated moment in a criminal proceeding that, frankly, the court has a lot of soft power means to address at that hearing. Certainly, no attorney wants to lose credibility in the face of a judge, and sharp questions, a sharply worded order can sometimes be enough. We don't always have to jump straight to sanctions just because the court thinks that maybe this attorney could have done a little bit better of a job. Or
Mr. Lindholm's argument that the earlier cases were relevant to Mr. Christensen's state of mind.
Judge.
I don't believe it was the same judge, Your Honor. I'm not 100% certain, but I'm pretty sure neither of them were the same judge. And my time is expiring. May I briefly answer? Thank you. I don't think it is indicative of Mr. Christensen's intent. First off, an act that occurred 2 years ago certainly is far removed from the incident at issue, and I think it's tough to draw a connecting line between those two. Also, 2 instances certainly are not enough to create the kind of habit evidence that normally that kind of prior conduct maybe could support an inference. And at the end of the day, the 2 prior instances are equivalent to a bad acts inference.
Hill, we adopted the ABA factors, and number 4 of those is the court can consider in a sanction matter a prior history of sanctionable conduct on the part of the offender. Does that open the door to considering what he had done in earlier cases?
Those factors are applicable to the amount of sanctions. In this case, the court bifurcated whether to impose sanctions and a separate hearing on the amount of sanctions. And the court expressly included in its order on whether to impose sanctions its consideration of these prior cases. So for those reasons, we would respectfully ask the court to reverse the district court.
District Court for Story County is hereby submitted, and court is adjourned for the morning.